ladies and gentlemen, and welcome to this very special evening with Justice Chemleswar, the second senior most judge in the Supreme Court of India. Let me give you, to begin with, an idea of what is planned over the next 90 minutes so that you have a better sense of the proceedings as they unfold. For the first 1 hour, I'm going to speak to Justice Chemleswar in a one-to-one interview, and in a moment's time, I'll tell you what are the range of subjects that I intend to cover. After that, we will take the selected questions given to me by specially chosen students, law students who are with us this evening. Now, the range of subjects that I want to discuss with Justice Chemleswar are many, and they include, but not necessarily in the order in which I'm going to tell you, the letter that he and 3 of his colleagues wrote to the Chief Justice in November last year, which was then made public at a press conference in January this year, the contents of that letter and its implications, as well as the developments that have happened surrounding that letter thereafter. I also want to talk to him about another letter that he wrote, I believe, last month to the Chief Justice of India, which was also circulated to members and other judges, which was about certain steps taken by the Karnataka Chief Justice. I want to talk to him about the National Judicial Appointments Commission, the problem about the memorandum of procedure, the struggle or impasse with the government over that issue, and I also want to talk to him about the fact that 2 months and slightly more have passed since the collegium recommended that both Justice Joseph and Ms. Indu Malhotra be appointed Supreme Court judges, but the government hasn't acted on it. So there is, in fact, a wide range of issues which I hope to cover over that 1 hour. Because many of these are issues which are technical, because these are issues where accuracy and precision is a prior requirement, I hope you will understand and forgive that some of the questions, particularly the technical ones, I actually will read out rather than rely on my memory to get right. Justice Chemleswar has assured me that even if at times he is diplomatic, he will not evade and avoid any question, and he will answer as fully as he can. And I hope, therefore, that as we come to the end of this evening, we can live up to that wonderful Latin motto, which is the motto of Harvard, Veritas. Justice Chemleswar.
Mr. Thapa, before we start, let me say something. I hope I'm audible. When I accepted the invitation, I was under the impression that I'll be meeting the former students of Harvard. I never realized that I'll be handed over to you. Now, well, the only thing is, from what you have indicated, apparently you are going to put me to some trouble. But anyway, let us start.
Bless you, sir.
Yes.
Bless you, sir. Let's start, Justice Chemleswar, with the National Judicial Appointments Commission. Yours was the lone dissenting voice. Do you believe the Supreme Court made a serious error in striking down the NJAC?
See, Ms. Thapa, I can't comment on that judgment beyond what I wrote in the dissenting judgment. The very fact that I didn't agree with the majority indicate that I didn't agree with them, and I don't see it as the right view in law. Beyond that, what is the comment I can make on the judgment? Obviously, once a judge, please remember, since it's a Harvard club, there's a wonderful quote from one of the professors of Harvard, Lawrence Tribe. He wrote a wonderful book on American constitutional law. The preface he said, "I do not consider the judgments of the Supreme Court to be synonymous with the constitutional truth. A court which held slaves to be non-persons, Dred Scott. Separate is equal. Until Brown's judgment came, every kind of segregation was justified by the American Supreme Court." And of course, the third, pregnancy to be a non-sex related subject. There's some stray comment in that Planned Parenthood case. Could either hardly be final or infallible. One second. But then he says, Such passing finality as the judgments of the Supreme Court have is essentially a compromise between order and chaos. Let us start with that.
Now, the important thing that I'm going to pick up for the audience is how you began that quotation. I think we need to improve your mic. Give us a moment, ladies and gentlemen.
But somebody else's...
They want you to speak louder, sir.
Further.
A little louder. Oh. The important thing that I'm going to pick out of that answer is how that quotation began. I don't believe judgments of the Supreme Court are synonymous with truth.
Constitutional truth.
Constitutional truth. Right. I take that as a comment on the majority judgment striking down the NJAC. In an interview to the Hindustan Times on the 24th of February this year, the Law Minister Ravi Shankar Prasad said there was need for an audit of how the collegium was functioning. After the Justice Karnan experience, would you agree an audit of the collegium system is necessary?
Yes. Anything in a democratic society, periodic audit is always necessary to see whether we are progressing on the right lines or not.
And I take it the collegium system has never been audited at all since it came into being.
It all depends on your definition of audition. What is the auditing which you are talking about? It all depends. First of all, it is
an attempt to assess whether it is promoting and selecting the right sort of people or whether the collegium system is producing judges who ought not to be chosen in the first place.
If you are making it as an absolute statement, I beg to disagree with you.
As a relative statement?
See, I'll tell you something, Mr. Thapar. No system created by human beings can be perfect. This country experimented with a particular system of appointments till the second judge's case, what we call as, popularly known in the legal circles as the second judge's case, that 9-judge bench judgment, where this collegium system was introduced. Thereafter, it was a different experiment for the last about now 25 years. There are always problems. The question is, democracy, we keep experimenting with it.
But despite those problems, you believe an audit of the collegium is a good idea?
Certainly, good appointments were made. There have been some lapses somewhere. Maybe accidents, maybe failures of assessment. So many things might have happened. There could be mistakes. Therefore, there is a time for men. It's always necessary and it's good to take an auditing of the system.
Let's come, Justice Chelameshwar, to the present struggle between the collegium and the government over the memorandum of procedure. In the letter that you and your 3 colleagues wrote to the Chief Justice in November, which was made public at your press conference in January, you said that the collegium had finalized and sent the memorandum of procedure to the government in March 2017. And then in that letter you said, and it's important, I'm quoting it, the government has not responded, and in view of this silence, it must be taken that the memorandum of procedure finalized by the collegium has been accepted by the government. The problem is, in an interview that he gave the Hindustan Times in February, Law Minister Ravi Shankar Prasad actually said that he had responded to the collegium in July. And in his response, he had pointed out that he wanted, firstly, a screening committee to select candidates before they were recommended by the collegium. And secondly, he wanted to know the criteria for making the recommendation. Were you and your colleagues not made aware of the existence or the details of this letter?
I am not aware of this letter.
At all?
No, I am not aware of this letter.
Does this mean that the Chief Justice did not tell you?
It means I am not aware of it, that's all. When I say I am not aware of it, I am not aware of it.
This suggests to me that you were kept in the dark, you and your colleagues.
Choice of the language is yours, inferences are yours. I can make a statement of fact, I made it.
Is it not unusual for the members of the collegium, other than the Chief Justice, not to be informed that the government has responded? Is that not unusual?
Well, if you have read my judgment in NJAC, I made a comment on this. Some of these documents are not available either to the society at large or posterity or even the members of the court. That's what I observed in that judgment. You can just check up that. I think advocate sitting here know that.
This is very important because what you're saying is that the second senior most judge of the Supreme Court was not made aware that the government had responded to the collegium in terms of certain things they wanted put into the MOP. You weren't aware.
Ms. Thapa, if it's a cross-examination, I'm a very old hand at it. I gave the answer once. Any number of repetitions will not help. I said, I am not aware of that letter. I have not seen it. It is not brought to my notice. Sorry? Yeah.
Can I ask this? You must have read in the Hindustan Times when Ravi Shankar...
I didn't see that. I didn't see that.
You didn't see that?
Ah.
Can I put to you, for your opinion, some of the things Ravi Shankar Prasad would like to see put into the memorandum of procedure? For instance, he says there should be a screening committee mechanism to select candidates before the collegium recommends names. Do you agree with that?
I have a difficulty in answering this question. The reason is this. Under the orders of the Supreme Court in the NJSC matter, the memorandum of procedure is required to be finalized between the Government of India and the Chief Justice of India in consultation with the 4 senior most judges of the Supreme Court. So therefore, so long as I continue to be a member of that select 5 collegium, I can't offer my individual views sitting here. It will have to be only in a body where the deliberations take place. So therefore, I will not be able to answer.
That I understand. Something that is known to the public is that the government is insisting on the right to reject collegium nominations on the grounds of national security. It's also equally well known to the public that the collegium is strenuously opposed to this unless the full national security concern is declared to the collegium. My question is simple. How intractable is this problem?
Personally, I don't think it is such a insurmountable difficulty. If the purpose of both the government and the collegium is to find out the most suitable persons for the appointments, I don't think there should be any difficulty about it. If for any reason government thinks a particular candidate's elevation to the bench would pose a security threat to this nation, all that the government is required to do is to give the basis on which the government comes to that conclusion. I don't think any collegium would be so unreasonable to reject the government's opinion if it is supported by material.
So your position is that if you want to reject a name on grounds of security, you must give us the full reason why, the details, the evidence.
See, when we are talking about give us, it's not individually me, X, Y, Z.
The collegium.
The collegium, and it's a body of shifting mass. I am here for another 2.5 months. Some more people will come. The question is, we hold it in trust for the nation, for the people.
Can I ask, has the collegium said to the government, we're happy for you to reject names on grounds of national security, provided you can explain to us fully why you're doing it and what the basis or evidence is? Have you explained that to the government?
Yeah.
That's a yes, forgive me.
Sorry?
That is yes, you said.
Yes, I said.
What response did you get from the government?
I have not heard anything so far.
So
Once again, you're coming back to the same
So
question.
on this, the government is silent. They haven't
for
got
the government
back.
to take a call.
The ball is in the government's court, in other words.
Yes.
Now, it's just over 2 months, I believe, since the collegium recommended the appointment of Justice K.M. Joseph and Miss Indu Malhotra as Supreme Court judges, and the government has not responded. Many people believe that the government is sitting on this matter because it doesn't want to elevate Justice Joseph, because as Chief Justice of Uttarakhand, he was the person responsible for reversing the dismissal of the Uttarakhand government. Do you share that fear that this could be the reason?
As of now, I don't share any fear or anything like that. I would just like to see what the government says about it. Government has not said anything so far on that.
They've taken just over 2 months.
Huh?
Just over 2 months has
Yes,
lapsed,
yes.
and they've said nothing.
Not so far.
Is it worrying you that they've been silent for so long?
I will not say worry is the right word, but we are concerned. At least I am concerned about it. I am sure the court is concerned about it.
Can I ask, has the collegium reiterated these names to the government and said, 2 months have passed, we want you to accept these names? Have you reiterated?
No, there is no such reiteration.
No reiteration at all.
Not so far.
Can I ask, have you within the collegium asked the Chief Justice, why have these names not been reiterated?
I will not answer this question.
Can I interpret that answer?
Anybody can interpret.
Normally people choose not to answer the question because the answer would embarrass the Chief Justice. It seems to me you asked him why he hasn't reiterated, but he hasn't given an answer.
Sorry. Why only the Chief Justice? It could be embarrassing to me also. That could be to... But anyway, those inferences, it's a hope.
I'll tell you why I'm pressing this point. I'm going to quote from the Supreme Court website. This is what the Supreme Court website said on the 2nd of February when those two names, and in particular Justice Joseph's name, was put up. And I'm quoting, "The collegium considers that at present Justice K.M. Joseph, who hails from the Kerala High Court and is currently functioning as Chief Justice of the Uttarakhand High Court, is more deserving and suitable in all respects than other Chief Justices and other senior puisne judges of high courts to be appointed a judge of the Supreme Court of India." That is a huge statement of support. And yet, for 2 months the government hasn't accepted the name and the collegium hasn't reiterated it either. Isn't that strange?
Well,
You're very articulate with that Sometimes, sir, a smile and a speaks volumes, and I think it's spoken volumes to the audience.
Mr. Thapa, I'm sure you must have read those famous Vikramark stories. The last story, 24th story, you remember?
Please tell me.
The full story is not necessary. Vikramarka smiles. He maintains silence, and the answer to that question is silence.
I think every member of the audience is learning to interpret and understand your silences and your hmms. And as I said, never has a been such an articulate word as this evening. Let's now come, Justice Chalameshwar, to the letter you and your 3 next senior colleagues wrote to the Chief Justice in November last year, which was made public at a press conference in January this year. That was, I'm sure you'd agree, a totally unprecedented step, and it hit the Indian judiciary like an earthquake. Let me start with a very simple question. What prompted you to write that letter and then make it public?
The reasons which prompted us to write that letter are contained in the letter. The letter is in public domain today. What compelled us to make it public is that also we made it clear in the press conference that in spite of our best efforts, we could not achieve what we thought would be the right solution for the problem. Therefore, we thought we had no choice but to make it public.
You made it public because of your anguish, and if I can use the word frustration?
Of course, what else? Mr. Thapa, please remember, to the date I am left with some 28, 29 working days. Technically, my retirement is 22nd June. And I am on record more than 1.5 years now after retirement, I'll not seek any employment under any government. I made it 1.5 years back. So what would be my interest in this? What would be mine, for that matter, my 3 colleagues? What would be their interest in this matter except, now, if our perceptions are wrong, that's a different matter. Well, it's open for, there has been a huge controversy, I know it. That the voices which said that we ought not to have done this and all those things. Yes, I have no problem with that. But, oh, it's booming occasionally, that's why I just kept it slightly away. But what else, what other interest can we have? Of course, what other interest can we have in that matter?
So it was your anguish.
Of course it is.
Your frustration.
Of course, frustration. These are dangerous
anguish.
Words. Yes, certainly anguish.
You felt you had no other option.
We had no option.
But to speak out in public.
Yes.
Let's come to the contents of the letter. The first paragraph talks about, and I'm quoting, certain judicial orders passed by this court which have adversely affected the overall functioning of the justice delivery system and the independence of high courts, besides impacting the administrative functioning of the office of the Honorable Chief Justice of India. And then your letter refers to the order passed on the 27th of October 2017 in the R.P. Luthra versus Union of India case. Explain to us, why was that a problematic order?
R.P. Luthra's matter. R.P. Luthra's matter. See, in R.P. Luthra's case, the division bench, while dismissing the SLP from a judgment of the Delhi High Court, expressed an opinion that notwithstanding the direction of the Constitution bench to finalize the memorandum of procedure, the Constitution bench which heard the NJSC matter, the memorandum of procedure was not finalized. Therefore, there was a need to monitor the matter in substance, and whatever language it is said, that's what that bench said. The problem in this order is this, with utmost respect to the learned judges. In fact, they have identified the problem rightly, but the problem which prompted us to write is this. Under the NJSC judgment, the memorandum is required to be finalized by the government in consultation with the collegium. A lot of deliberations are required, and it's ultimately a matter of an assessment of the situation. If the matter is to be dealt on the judicial side by a division bench, the collegium would be bound by judicial orders. That would create a situation where it would be difficult for the collegium to handle the matter. Therefore, we requested, actually that request was made initially orally, saying that please take up this matter, list it before a constitution bench of the first 5 judges, because it is the collegium, so that anything is to be done by this constitution bench. Since it was not done, we had to put it in writing.
Can I just sum up what you said, because I think some members of the audience, because of the mic, may have had problem.
Okay.
Basically, if I've understood correctly, you said that the problem with the Luthra order was that a division bench was trespassing on what should be...
No, please.
Not trespassing, but was seeking to monitor.
The division bench has rightly identified the problem. Question is, who should deal with that problem is the question.
The collegium and not the bench.
Because if the MOP is to be finalized by these people, government and the collegium, if a division bench passes some order, whatever way, it would become difficult for both the government as well as the collegium to handle the matter thereafter, because we would be bound by that. And that would not be consistent with the directions issued in NJSC matter. That's what we believed.
Okay.
That's what 4 of us believed, and we wrote it.
Is what happened in what's called the Prasad Education Trust case, where Kamini Jaiswal was the petitioner, another example of a problematic order passed by the Supreme Court? And if it is, what were your concerns there?
I didn't get your question. Can you kindly repeat?
I will happily, sir. Is what happened in the Prasad Education Trust case, where Kamini Jaiswal was the petitioner, another example of a problematic order passed by the Supreme Court?
Actually, Prasad Education Trust matter came much later
Absolutely.
than the
I know.
letter.
Is that another problematic order as far as you're concerned?
Well, I don't want to comment on that aspect of the matter because I have a difficulty in that. A lot of things are said about that order. I'm still struggling with the question, what was it that required a reversal of the order passed by a bench presided over by me and another learned judge? The larger bench said certain things. Chief Justice, the master, we never disputed that. And they relied on an earlier judgment saying that a judge can't pick up the case of his choice. I didn't pick up the case for deciding that matter. Since a matter was presented to me on that day when mentioning was officially required to be made before the second court. Somebody mentioned it. Having regard to the fact, if you recollect the facts of the case, a former judge, a High Court judge who had been an acting Chief Justice for quite some time of one High Court, was arrested in this country, later released on bail. And the papers placed before me showed that that man was trying, that's the allegation at least, since the matter is pending trial, man was trying to pollute the streams of justice. I thought it's too serious a matter for the nation and the institution, and matter required hearing by a constitutional bench. If you recollect, I don't know. All that I said is let it be listed before a constitutional bench of the first 5 judges, senior most 5 judges. Why senior most was the later question. Well, it could have been the last 5 judges of this court also. And somewhere I had to choose. Now, one of the greatest lawyers known to this country of the 20th century, I was just only checking up whether he's here. He's not here. He wrote in his book that at the height of emergency, when the ADM Jabalpur case was about to be heard, some senior members of the bar heard rumors, I'm using the language from that this thing.
You're talking about Mr. Nariman?
Of course I am. Yes, I am. Heard rumors that the Chief Justice was likely to constitute a bench with those judges who are likely to be in tune with the supposed views of more or less that's the language used by. Therefore, they requested Mr. Daftari to go and intercede in the matter. And Mr. Nariman wrote. Eventually, to our pleasant surprise, a bench was constituted with the senior most 5 judges of the court. That's what I thought, well, if there's some such thing, and if you recollect, there was another event. Sometime back, there was another unfortunate case.
Can I?
Oh, okay, yes.
Can I request you to hold it in your right hand? Get closer to the caption.
Okay. Oh.
Can I ask you 2 questions about that particular instance? As you said, the matter was referred to you on a day when you were in charge of special mentions. Therefore, when you constituted a bench, do you believe you were acting within your powers?
I did believe, I still believe it.
You were not transgressing or...
I still believe it.
You weren't transgressing on the Chief Justice's prerogative?
I don't believe so.
One other question. Within 24 hours, the Chief Justice overturned your order, constituted another constitution bench, and chose to preside over it himself, although many people believed that in this matter, the finger of suspicion could be pointing towards him as well. Was that a lapse of judgment on the Chief Justice's part?
You can decide for yourself. I don't want to say anything.
Now, in your letter, I'm just going to repeat, sir, can you keep the mic near? Yeah.
No.
I'm just going to repeat your answer because it's another one of those articulate silences. You can decide for yourself was Justice Chelameshwar's answer. Now, in your letter, I'm going back to that letter of November last year, which was made public at the press conference in January this year. You said, and I'm quoting you, there have been instances where cases having far-reaching consequences for the nation and the institution have been assigned by the Chief Justices of the Supreme Court selectively to benches of their preference without any rational basis for such assignment. Can you give me one or two examples of the sort of cases you have in mind?
May I say this, once again quoting from Mr. Nariman. Just walk in the corridors of the Supreme Court, you will still hear the same rumors on which Mr. Nariman acted on that day.
Unfortunately, Mr. Nariman is not here to explain what he meant. So let me repeat my question, because this is critical, sir. To many people, the charge that Chief Justices are selectively appointing judges to benches of their preference was a charge akin to dynamite. So I'm just asking a simple question.
That's what I'm saying.
Give me one example of a case where you believe selective preferential benches were chosen.
Once again, you want me to get into this controversy saying that, look here, this man is doing this, doing that. Is it the purpose?
No, not at all,
No.
sir.
Then,
You made...
now,
Can I suggest a case to you?
yeah.
What about the Jaya Lalita case?
Yeah.
You said?
Yes, let us see. I'm not saying that what exactly happened is not the question. If this master of the roster's power, ultimately, what is the purpose of this? If you recollect, court like the American Supreme Court, where the entire court sits as one body, this question doesn't arise, this principle doesn't arise, master of the roster, because the entire court sits. Now, this power is available to the Chief Justice where the multiple benches are there. The whole idea is to make a more efficient system. If that is the purpose, was it served in that case? It was a case, you please remember, judgment was reserved for almost a year.
You're talking of the Jaya Lalita
The very
case.
same case which you mentioned. So what purpose that serve? The assessment, did the assessment not fail there? And what purpose? Let's not go into why such an allotment was made is not the question. At least the assessment failed there. So therefore,
Can I ask you another one? There's the Justice Lawyer case. Many people believe that the trigger for your press conference in January was the meeting you and your three colleagues had with the Chief Justice that morning about the Justice Lawyer case. And my question is a simple one. Why do you consider the allocation of the Justice Lawyer case to Justice Arun Mishra's bench inappropriate or unsuitable?
we never said anything like that. We never said anything that is inappropriate or appropriate. What transpired that morning is never mentioned in the press conference. A lot of things transpired, but then it was a joint conference by 4 of us. And then I am not going to answer that question unless all my 4 The other 3 colleagues are there.
But what about the justice lawyer case was of concern to you?
Well, it's a different matter that the matter was listed that day. Therefore, people started drawing inferences from that.
Were the inferences wrong?
I'm not saying anything. That's what I'm saying. I'm not going to make any comment about that matter and the events that preceded that.
Let me ask you this. How do you understand the term master of the roster? Does it give the Chief Justice the power and authority to appoint whatever sort of bench, whatever composition of bench he wants?
Undoubtedly, the Chief Justice would have the authority to constitute the benches, but under a constitutional system, every power is coupled with certain responsibilities. The power is required to be exercised, not merely because the power exists, but for the purpose of achieving some public good. You don't exercise the power merely because you have it. The exercise, I suppose the Supreme Court has been repeatedly saying it in every case, wherever those questions arose, that all power is trust. It has to be exercised for the benefit of the body politic.
So the power to appoint benches cannot be exercised arbitrarily or whimsically. There must be a clear rationale that is obvious.
Yes. Yes.
In his recent petition, I believe it was presented to the court yesterday, former Law Minister Shanti Bhushan has listed.
I don't want to comment about
No,
it.
I'm not asking you to comment on that.
Pending case.
No, I'm not asking you to comment on that. But he's listed 10 instances of Chief Justices allocating cases to preferred benches. Are there really as many as that?
I have not seen the petition, except a news item in the morning. I have not seen the petition. Since it's a pending petition, I don't want to make any comment on that.
Let me ask you something else. And these are critical questions, Justice Chelameshwar.
Yeah.
When a Chief Justice selectively assigns cases to benches of his preference without any rational basis for such assignment, and those were the exact words, I think, of your letter, aren't you claiming that the Chief Justice is actually allocating cases in a way that will predetermine the outcome to suit his preference? In other words, he's giving the case to benches which he believes will deliver the verdict he wants. Isn't that what you're really saying?
Is it a question or is it a statement you are making? Is it a question or is it a statement you are making?
I'm asking you for the real meaning of what you charged several Chief Justices with. Aren't you saying that they are actually setting up benches to get the judgment they want?
I'm not saying that. See, let's not talk about any one of the pending cases or decided cases. Just take a hypothetical situation. If a particular case is listed before you, you may reach a conclusion, a particular conclusion. The very same case listed before me, I may also reach the very same conclusion which you are likely to reach if it is assigned to you. Question is not that whether a particular judge would decide in favor of or against it. Even those perceptions exist. That's what I told you Mr. Nariman wrote. That was the perception with which they went that day. That's not the point. The question is, what is the basis on which some of these sensitive matters are allocated? And look here, none of us, I have spent about 20 years as a judge. I am not dying to hear one more case. I am not dying for any glory which I can get out of writing a great judgment. That's not the point. We are not asking to, but question is, are we following as a system, as an institution, are we able to sustain the faith of the general public in this country? Would this kind of an allocation be good for the institution? That's what was troubling us.
And
Now,
you're saying that these selective preferential benches is undermining faith in the institution.
I believe so.
And as a result, it is also damaging for India's democracy.
Yes. See, it is repeatedly said by the Supreme Court in the context of administrative decisions, not only the Supreme Court, world over, wherever this jurisprudence is followed, that justice must not only be done, but must also appear to have been done. That's more important.
And when cases go to preferential benches, it doesn't appear to have been done necessarily. The process is as important as the end result. If the process,
Of course it is.
if the process is vitiated, people raise questions about the result.
I don't even say vitiated. If the process is not transparent, it can lead to suspicions, and suspicions always are dangerous for institutions.
Can I ask you this? Have cases been allocated to preferred benches just once or twice? Or are there several such instances? Is it a proliferating problem or is it a small problem?
There have always been instances.
There have always been instances of this.
Instances.
You mean it's been happening for quite a while? This may be an awkward question for you, but it's one that I have to ask you. When this sort of selective choosing of preferential benches happens, are the Chief Justices doing it for the benefit of the executive? Are they, in some sense, beholden to the government and furthering the government's interests? Is that why preferential benches are chosen?
I'm not answering this question.
Silence can be interpreted in any way. Can I put this to you? When preferential benches are chosen, would you say that justice is not being furthered, it's being impeded, that justice is being possibly distorted or denied, not delivered and expanded?
I think, Mr. Thapar, I think we have discussed this problem enough. I think let's leave it there. I have made a statement earlier. We have discussed it enough. I think there is no point in going on and on with this.
I have one last question and then I will happily leave it. But it is probably the most important question this evening. It is probably the most important question this evening. Do we have sufficient grounds for seeking the impeachment of the Chief Justice?
I read the other day, one of those magazines wrote an article that I should be impeached. I don't know why this nation is worried about this impeachment business, obsessed about it. In fact, we wrote in that judgment, me and Justice Ranjan Gogoi, in the judgment of Justice Karnan, apart from that, there must be mechanisms to put the system in order. Impeachment can't be the answer for every question, every problem. Looks as if everybody... Looks as if everybody is suddenly, certain phrases gain currency in a particular season. Now, I think for the last 2 months, there is a current popular phrase, impeachment. But I just read a couple of days back, somebody said, I should be impeached. I said, fair enough. It's a free country. And you remember that old saying, I will not agree with you, but I shall protect your right to say so.
Absolutely. That was Voltaire. So if I understand you correctly, what you're saying, Justice Chelameshwar, is that impeachment is not always the solution. What we need to do is to correct the system.
The system, that's all.
But correcting the system means you need to stop Chief Justices, in the plural, not in the singular, allocating cases
Set up
to
a proper
benches.
system. Set up a proper system whereby these problems and these doubts may not arise. If there is a proper system in place. See, for example, just yesterday the Supreme Court passed an order in the matter of the recruitment to various posts. Why don't you video record the whole thing? So what is it saying?
In a recent lecture, Justice A.P. Shah said that perhaps India needs to adopt the system that exists at the European Court of Justice, whereby allocation happens systematically. Do you think we need to set up some sort of system like that so that this fall in the image of the people doesn't happen?
Some system is required to be set up. But in what form it should come, it's a matter for deliberation by all the stakeholders. Let there be deliberation, let a system be devised.
One other question, and then I'm moving to another subject. You know, this whole problem of chief justices allocating cases to preferential benches doesn't just raise questions about the integrity of the chief justices, it also casts aspersions on the junior judges, because you're suggesting that the junior judges to whom these cases are allocated are somehow pliable and more willing to do the chief justice's bidding than others.
Not necessarily. I told you, not necessarily. I told you, maybe even the senior junior business, we never use this word senior junior in that letter. It's subsequent intervention, somebody invented it. It's not the question of, at least I, for one, never believed. I had been a chief justice.
Are they pliable?
One second. I had been a chief justice of 2 high courts for 4.5 years almost. And I'll tell you, barring a formal full court meeting with an agenda, in an informal meeting, I never sat at the head of the table. I used to simply go and sit with any one of my colleagues and
But can I ask this, sir? But when cases are allocated to preferred benches, aren't those preferred judges chosen because they are pliable? Doesn't that follow?
No, not pliable. Maybe an assessment that a particular, for example, 70s, you remember, the government came forward with a theory that of a committed judiciary. It doesn't necessarily mean that individually there was something wrong with them, but they have a certain political orientation or a certain economic philosophy. Therefore, they are likely to decide cases in a particular way, which would be consistent with the prevailing political philosophy of the government of that day.
So these judges
No,
are
it's
not
did
pliable.
not necessarily mean that when we talk about preferred this thing, it's not that individually those judges are good or bad. I don't want to comment about my colleagues in that manner. But then this creates a problem in the system. It creates doubts, questions about the integrity of the institution. That's what we meant.
And that is your chief concern.
Huh?
Doubt, and that is your chief concern.
Of course
Doubts
that is.
about the integrity of the institution.
That's right.
Now, one of the things that happened after your letter and press conference is that the Chief Justice has begun the practice of publication of the roster. But it emerges that all PILs, as well as all appeals against decisions on PILs taken by high courts, as well as what's called all accountability matters, all of these are going to the Chief Justice of India,
Right.
not to you, not to any other judges.
Not necessary. He's the master of the roster. If he chooses to do that work, let him do it. If he has the energy to handle the entire work, let him do it. I am not complaining about it. I never complain. On the other hand, I have reached a stage. Well, I would like to be doing the minimum work for the next 29 days and get out of it without straining myself.
What about something else? I noticed that none of the top 4 judges of the Supreme Court, who also happen to be the 4 judges who wrote that letter, are handling important matters presently before the Supreme Court, such as the Ayodhya case, or the Aadhaar case, or the land acquisition case. Is that just a coincidence, or is it deliberate?
I don't know. You should be asking this question to somebody else. At any rate, I told you, I am least interested in any one of these cases.
Do you ever get the feeling that the Chief Justice keeps you out of important cases deliberately?
See, I always believed from the beginning that there's a great way of doing small things, there is a small way of doing great things. Whatever is assigned to me, I can handle it. I can see, if you look at my own judgments, some of those things were not these high-fly cases, but I suppose I produced reasonably good. I mean, anyway, it's for the senior members of the bar to make an assessment the day I demit the office, what contribution I made or I didn't make to the system. That's a different matter. But I never believed that the importance of a judge depends upon the nature of the case he handles. The importance of the judge.
You don't care what sort of case you get.
Yes, I bother more about what I contribute to.
You don't care if people turn around and say important matters are not being given to Justice Chedameshwar.
I just don't care.
We're coming to the end of the 1-hour interview, and before I start taking questions, I want to touch on 2-3 small things. What is the state of the collegium today?
Sorry?
What is the state of the collegium today? I'm talking the 5-judge collegium.
Yes.
4 of you wrote the letter and went public. Is the collegium therefore divided 4 versus 1? Has it become dysfunctional?
How did it become? In fact, just 2 days back we made certain recommendations. Last week we made certain recommendations for some high courts. If the collegium has become dysfunctional, how was it possible to make these recommendations?
So despite the fact 4 of the judges wrote this letter, you're functioning.
Look here, Mr. Thapa. None of us is fighting for some private property here. We have differences on certain institutional issues. So that doesn't mean that we are not able to see eye to eye. Business is going on. We are taking decisions. Recommendations were made. In the last 10 days, for about 4 high courts recommendations were made.
Okay. Recently,
Yeah.
you've written a letter to the Chief Justice, copies of which were given to your brother judges,
Yes.
drawing attention to the inappropriate way the central government directly contacted the Karnataka High Court Chief Justice, requesting an inquiry into allegations against a district and sessions judge called P. Krishna Bhatt, without routing the matter through the Chief Justice of India. And you've also in that letter asked for a full meeting of the Supreme Court to discuss this issue. Clearly,
Just a little correction. I didn't say full meeting of the Supreme Court. I said full court on the judicial side.
a full court on the judicial side. Now, clearly you believe that the central government has acted wrongly. My question is, how serious a matter is this? Can you explain to us how serious a wrong
I think
is this?
this letter is self-explanatory.
But the letter has not come fully in public domain. It's only been quoted in newspapers. So explain to us, how serious a lapse is this by the central government?
See, that particular name was cleared by it was recommended obviously by the High Court Collegium some 3 years back, roughly around 2.5 years back. If I remember right, it was March 2016. After all the procedures, the Collegium, Supreme Court Collegium, that is the first 3 judges of the Supreme Court, relevant in the context of the appointment to the High Courts, cleared that name, forwarded to the government, and I was not a member of that collegium at that point of time. It was a collegium headed by Justice Thakur. Other honorable members were there. It was cleared, it went to the government. A lot of things happened, correspondence, a lot of things happened in that matter. The matter came back again. A second time, the collegium recommended it. This time it was a collegium headed by Chief Justice Kher. I was the 3rd member of it. We reiterated after taking all the relevant factors into consideration, including the present Chief Justice of India. He was the number 2 in that collegium. Chief Justice Kher, Justice Deepak Mishra, and me. We reiterated. If the government still finds that there is something to, because I don't want to enter a debate on what is wrong or what is right in that matter, still finds necessarily, I believe, the communication should be to the Supreme Court of India, not directly to the Chief Justice of the High Court, because the Supreme Court had cleared it twice. Therefore, I thought it was not constitutionally proper for the government to have. And then, unfortunately, the Chief Justice of Karnataka chose to act on it. Therefore, I had to write on.
I'm coming to the end. Let me ask you 2 questions. Are you at all apprehensive that Justice Gogoi, who was one of the authors of the letter, who was
Which letter?
The letter of November, who was also one of the participants in the January press conference, might not be elevated to Chief Justice when Justice Mishra retires? Are you at all apprehensive about that?
I'm not an astrologer, Mr. Thopper.
But are you worried that what has happened to earlier justices i.e. get superseded, might happen to Justice Gogoi?
I hope it will not happen. If I repeat, if it happens, it will only prove that whatever we said in the press conference is true.
Finally, Justice Chelameshwar, I'm going to ask you a devil's advocate question.
Okay.
Many people have applauded you and your colleagues for going public. But the truth is, almost as many have criticized you and accused you of breaching judicial discipline. How do you respond to the criticism?
Anybody who enters a public office can never avoid criticism. And the criticism, as far as we four are concerned, that we went to the press, I was really wondering, where did this principle come from and what was the context in which this principle came from? Judges were not expected to debate in the press about their judgments. Well, I come for a meeting like this, I go somewhere and there is, obviously, press would be there, they report something. Is it prohibited? Similarly, when we're talking about the administrative problems, we were not breaching, at least I believe, or we four believe, that we were not breaching any one of those time-honored principles that we should not address the press. Now, these were principles which were evolved in countries where the job of the judges was simply judging. The Indian judiciary and the Indian constitutional system took a different turn. We have today, for the last 25 years, the authority to decide upon the suitability of judges, advocates for elevation to the high courts or judges for elevation to the Supreme Court. These are all virtually administrative functions, and these kind of functions were never discharged by those countries, those courts and those countries where this principle originated.
So you have no qualms or second thoughts about going public and speaking out at that press conference, or even going public and speaking out tonight?
Yeah.
Can I quote to you guideline number 9 of the Restatement of Values of Judicial Life adopted by the Supreme Court in 1997. The guideline says, a judge is expected to let his judgments speak for themselves.
Right. That's what I said.
He shall not give interviews to the media.
About what? About the judgments?
But you can talk about other things.
Huh?
But you can talk about other things.
Why not? Why not? If you are quoting that, please read it. What does it say?
He shall not give interviews to the media.
Suppose somebody asked me, you asked me the question, first question, that's what you asked me about NJSC. I refused to look here. I wrote it. It's for you to form your own opinions on that. My views are there on record. I am not going to justify it or defend it anymore. I may be right or wrong.
My last question, sir. You raised
in fact,
deep concerns about the way the Supreme Court functions on the administrative side.
Right.
There are orders being passed which are undermining the institution. There are allocation of judges to benches which you call preferential. Do you see this changing? Because as you pointed out, this is not one Chief Justice. It's been happening, you said, for a while. Do you see it changing? Mr.
Thapar, please recollect, Justice Chelameshwar might be a very wholesome judge, might not be a wholesome judge. It's for the nation and history to judge. Let them decide it. I'll only quote, I'll remind all of you of one thing. Justice Bhagavati, he was an icon. Justice Bhagavati In Sankal Chand's case, that was a case where 16 judges were transferred during 1975 emergency. One of the 16 transferred judges challenged his transfer. The matter came to the Supreme Court. Deciding that case, Justice Bhagavati wrote, one of the arguments was that whether the judge's consent is required before he is transferred. In the context, the argument of the government, the Attorney General, was that there is consultation with the Chief Justice before transfer. Therefore, it's a sufficient safeguard for the independence of the judiciary. And Justice Bhagavati wrote, I'm sure my advocate friends and law students would know, howsoever high a personality in the context of the Chief Justice, that's no safeguard. All the 16 transfers during the emergency were made in consultation with the then Chief Justice. So the point is not X, Y, Z. It's the system we are talking about. This problem always existed. And when Justice Verma wrote the second judge's case, this concept of collegium was created. Justice Verma specifically said it's the plurality which is the safeguard. And Justice Verma said in his judgment, as a matter of practice, till now it's what has been happening as a matter of fact. He only put it formally in a judgment.
So what you're saying is the more people speak out, the more likely it is the system will be changed. Silence will protect the system.
Yes.
That is why...
No, protect the system, destroy the system, I'm not talking about. If we believe in democracy, if we want democracy ultimately means a transparent system. Let the system be a little more transparent. Let appropriate mechanisms be set up. That's all we were talking about.
I thank you, Justice Chelameshwar, for speaking, for answering my questions, and more than anything else, for devising that wonderful way of saying yes without using that three-letter word, the smile and the word hum. Justice Chelameshwar, we have 5 questions sent in by law students. Unfortunately, I haven't been given in every case the name of the student, but the first question is this: would scrapping the collegium system not lead to increase in executive interference in the judiciary?
Who is asking for the scrapping of the system? Did anybody ask for it?
The NJAC, if it hadn't been struck down, would have effectively scrapped the system. And you were in favor of the NJAC.
No, once again. Please recollect the amendment. It didn't scrap down the system of collegium totally. Even in the NJAC, the constitutionally amended provisions of this thing provided for 3 most members of the Supreme Court to be part of that NJAC. It only brought in other elements, the civil society, and of course, a representative of the government there. The consultative process contemplated by the original constitution between the government and the Chief Justice subsequently interpreted by the Supreme Court to mean a plurality of the judges, still continued. Only thing is the NJAC brought in some more elements into it. Well, the Constitution bench thought it was unsustainable. That's the law.
But this is a very interesting thing you're saying. You're saying that the NJAC wouldn't have scrapped the collegium, it would have, in a sense, expanded the collegium to include 1 or 2 others.
Well, you may say so, yes. Yes, in a way, yes.
Unfortunately, your colleagues on that bench didn't agree with you.
Yeah, sorry?
Unfortunately, your colleagues on that bench didn't agree with you.
Well, it's fortunately or unfortunately is a matter of your opinion. They didn't agree with me is a fact.
The second question, Justice Chelameshwar, comes from Neeraj Kumar, a student of Delhi University. My question is, this is his question. My question is regarding the existence of multiple courts in the Supreme Court of India, unlike the Supreme Court of the USA. It often leads to disagreement and the overturning of rulings given by other benches of the Supreme Court.
This is a question actually which which requires a full-length debate in a proper this thing. I'll only mention one thing. Delivering the first Saraladi Memorial Lecture in Hyderabad way back in 1989 or 88, I don't really remember now, Chief Justice Hidayatullah, former Chief Justice Hidayatullah, I think when he delivered this lecture, he was the Vice President, I think, subject to correction dates, I don't really remember. He delivered the first Saraladi Memorial Lecture. He commented about this, saying that in his days, the Supreme Court always sat in because those days the total number of the judges of the Supreme Court was much lesser. Then Justice Hidayatullah, in his speech, it's printed, it's published, all those speeches were published in the form of a book. He said, the Supreme Court has become a two-judge court now. And the problem started, I mean, it's a matter which requires a full-length debate. There are a lot of problems in this system, I mean, in these aspects of the matter.
Can I ask you a simple question? Do you think we need to consider changing, amending, altering the system? Do we need to consider changing, amending, altering the system?
Once again, it is a matter for debate. I may have views on the matter.
I'm asking for your views.
My view? Well, I think some kind of revisiting is required.
What sort of revisiting would that be?
Well, creating a more efficient system. Efficient, I'm not talking in terms of the beauty of the judgments of the thing, but in terms of the working of the system. Look here, we have some 50,000 and odd pending cases. Whether all these cases are really required to be dealt by the Supreme Court is one question. In fact, a couple of years back, maybe 3 years back, I had the honor of delivering H.R. Khanna Memorial Lecture. I dealt with this problem. These multiple benches itself is a contributor of a great problem of dependency. So therefore it requires some analysis, some examination and restructuring of the whole system. That's what I believe. But it requires a full-scale debate. It can't be just a one-line answer, can't be possible in this.
The next question, Justice Chemleswar, refers to something you wrote in your famous letter of November to the Chief Justice about allocation of cases to preferred benches.
Back to that again.
Oh, the question, not me, sir. The question. The question. When you write to the CJI for allocating important cases to senior judges in a court where every judge is equal, then are you suggesting that senior judges are more equipped in dealing with important questions?
First of all, did we mention the word senior in that letter anywhere?
You didn't, but I'm only reading the question.
So that's the answer. We never said senior. See, nothing like, see, at this stage, when each one of us sitting in the Supreme Court, barring a few who came directly from the bar, each one of us must have spent at least 15, 16 years in high courts, around that. And coming here, but at this stage, what is the seniority? Seniority is not the question here. Seniority for certain purposes, because the system, when the second judge's case said collegium should be the first 3 judges. Well, only for certain purposes, not for the purposes of deciding cases. Ultimately, the importance of the judgment depends upon the quality of the judgment, not who decided it. What reasons are given, what logic is given, what jurisprudential principle was laid down there. That's what matters, not how senior he is or how junior he is, quote unquote.
This next question seems to refer very possibly to a position you share, I'm assuming. It's talking about how judges choose judges. The question is talking about how judges in India choose judges. And the question is this a democratic way of deciding the issue of the appointment of judges? Doesn't this go against the principle of natural justice of not being allowed to decide in one's own cause?
I don't know, it's too complicated a question because there are too many concepts rolled into it. What is this natural justice about it? There's nothing like natural justice in these matters. Natural justice is a totally different concept. Now, judges playing a role in the matter of the choice of next generation of judges, well, it's a part of the Indian democracy. That's what happened over a period of 70 years. Unless you think that there is a prototype of democracy which is required to be followed everywhere in the world. All democracy is an experiment, wherever it is.
Our last question. What is the one common problem that all our institutions face? What is the one common problem that all our institutions face, and what is the solution?
What the father of the nation told us, speak truth. That solves a lot of problems if we speak, all of us speak truth. That solves a lot of the problems in this country.
You're saying the problem is a lot of us lie.
Well, we may not lie, but we speak half-truths. Half-truths. In fact, anyway, the context now that it's over, there's a wonderful book published almost 15 years back on Mughal India, titled The Last Spring by somebody called Mr. Abraham Irali is no more. In the epilogue, he writes about the Mughal society. Hypocrisy and psychopathy are the hallmarks of the Mughal India, he said. Indians seldom spoke. They communicated in knots and metaphors, which made it easy for them to break faith and still feel decent. That's what he wrote. And 500 years later, I don't think we're much different from that.